So the Enoch Burke case came before the High Court again yesterday, Wednesday, and firstly there was two applications, one from Enoch Burke seeking an injunction to prevent the school from carrying out a disciplinary procedure or process against him. They have a meeting set for January the 19th, a disciplinary meeting. The other application was from the school seeking sequestration of assets of Mr. Burke. The application for the sequestration of assets, according to Rosemary Mallon BL, wasn't ready to go ahead and was adjourned to next Tuesday. Mr. Burke's application, however, for the injunction preventing the school from bringing the disciplinary did go ahead and was ready to go ahead, and Mr. Burke was anxious to go ahead. Mr. Justice Brian O'Moore commented that he was surprised that Mr. Burke was seeking the relief of the court in circumstances where a previous High Court order made against Mr. Burke appeared to have been ignored and was not being adhered to. And Mr. Justice Brian O'Moore pointed out to Mr. Burke that it's an equitable principle that those who seek justice or those who seek equity must do equity. And Mr. Justice Brian O'Moore suggested that he was marking Mr. Burke's card in that regard. So the case was then commenced in the afternoon in front of a different judge, Mr. Justice Conor Dignam, on Wednesday afternoon, and Mr. Burke proceeded with his application, and fundamentally he was arguing that the disciplinary process against him should not go ahead because it was fatally flawed, that it would do irreparable damage to him and his career, that it was fundamentally flawed and was based on a process that was manifestly unfair and lacking in fair procedures and natural justice, and for that reason it should not go ahead. Mr. Burke also accused the chairperson or chairman of the board of management of the school of lying under oath in an affidavit. So Mr. Burke and his mother and his sister Amy were quite exercised by the fact or the allegation of the lying under oath by the chairman of the board of management, and asked Mr. Justice Conor Dignam what he thought of it or what he was going to do about it. Come 4 o'clock then, the judge said that the court would rise, and Mr. Burke and his sister Amy and his mother were very upset, dismayed, disappointed, and according to one of the newspapers, agitated that he was going to rise at 4 o'clock, and basically said that he appeared to be doing this to give the school a chance to respond or get ready or something of that nature. Mr. Justice Conor Dignam said that the suggestion that he was doing anything to allow the school time to prepare, etc., was an outrageous suggestion, etc., etc. The Burkes took the view that it was inappropriate to rise at this critical juncture in the case. In relation to Mr. Burke's arguments that the disciplinary process was fundamentally flawed and manifestly unfair and so on, he was referring to a report prepared by the school principal, back in August of 2022. Bottom line is, Mr. Burke said that he didn't have the opportunity to respond to that report, that findings of fact, etc., were made without his input, and that fundamentally that an email sent out by the principal of the school was not a legitimate staff instruction or instruction to staff, and the email referred to a recognised right of persons to be called the name of their choosing and pronoun, when the Equal Status Act, according to Mr. Burke, confers no such right. He said Christian beliefs on gender are informed by the scriptures, and he did not accept transgender ideology. If he obeyed the principal's direction, he'd be obliged to accept the student in question is no longer a male, and this I could not do. So basically Mr. Burke is saying that he has a strong case to succeed at the full hearing of the dispute on 7 grounds, including that the disciplinary process breaches his rights, that there was no misconduct, that there was no consideration by the school of his unblemished employment record over 4 years, or of his good name and employment prospects. And basically he's saying that the basis of the disciplinary process is a report which basically made findings and described facts without giving him an opportunity to respond, and was read and discussed before a board meeting to which he was not invited, and which had a predetermined outcome according to Mr. Burke. That is the basis on which he is saying that the disciplinary process should not go ahead. Basically it is flying in the face of natural justice and fair procedures, and it should be stopped. That's what he's asking the High Court to do. It will be interesting to see what they do, what the High Court does when the court resumes again today, Thursday. It's lunchtime now on Thursday, and the school's position in relation to Mr. Burke's application was set out this morning in the High Court. And the judge, Mr. Justice Conor Degnam, has indicated that he'll give his decision next Monday or Tuesday, early next week. The position of the school in relation to the application was that they were arguing that anyone coming to court seeking equity must do equity, and that Mr. Burke's continuing breaches of orders of the High Court are not the actions of somebody doing equity. Rosemary Mallinbeale claimed that Mr. Burke continues to knowingly breach court orders because he does not agree with them, and that should be a sufficient basis for refusing the injunction that he was seeking. She also said he's not entitled to the injunctions because he's failed to make out a strong case against the process likely to succeed at the full hearing of the dispute. She said that the circular, the Department of Education circular, governing a stage 4 disciplinary process sets out clearly the procedure to be followed, and it was wrong of Mr. Burke to contend that there was a fait accompli or a decision made already and the outcome was predetermined. Mr. Burke can make submissions and be represented at the disciplinary hearing, and if he's dissatisfied with the procedures and the outcome there, then he always has the option of an appeal and of other legal remedies. She said, the school says, that his application is premature, and while Mr. Burke may fear he may be dismissed, no such decision has been made, and any such fear is not the basis for an injunction. She also argued that Mr. Burke was giving too much reputation, or too much weight to his reputation, far too high, she said. She said that Mr. Burke is very much in control of his own reputation, and he alone has decided to breach court orders, and his actions have resulted in significant publicity. So they are the arguments of the school in opposition to Mr. Burke's application for an injunction preventing the disciplinary process from going ahead. There's a meeting set for next week, 19th of January, and that is the position. The judge will give his decision then on Monday or Tuesday of next week.